Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. If you've ever had a question about your employment law rights, then you've come to the right place. Welcome to Ask a Lawyer. I'm your host, Dana Levinson. Each week, we dive into different employment-related topics that are on many Canadians' minds. I'd like to welcome my guest for today, Jon Pinkus, partner at Simfuru Tumarkin LLP. Before we get to today's questions and phone calls, Jon, why don't you tell us why it's important that everyone understands their workplace rights and perhaps share a case from this week?
Well, that's right, Dana. It's so important because employment law is one issue that really touches most of us, because most of us, either if we are or someone in our family is working, we're spending most of our waking lives in the workplace. And when things go wrong in the workplace, they go really wrong, and it can be very stressful. Employment law is an area that has become increasingly nuanced, increasingly complex over the last 10 to 20 years. And I've seen people make time and time again mistakes that they cannot take back. So it's really important that you have someone to help you navigate through these difficult issues. And a perfect example is recently, I had a gentleman who contacted us after having been laid off since August of 2020, so almost 2 years ago. Didn't know there was anything he could do about it until he saw the show and realized that if you are laid off, that may be something that you can take action on. Now, in this case, this person had other people in the workplace called back. In fact, it happened to be younger people. And he noticed, as it so happened, that his job had been replaced. Someone had been put into his position. So it didn't look like he was getting called back, and he wanted to be able to do something about it because they just kept extending and extending the layoff. Well, the truth is that he can do something about it, because if you have not agreed to a layoff, then that is a termination. And in fact, it is just like any other termination. And you can go on EmploymentLawyer.ca, you can plug in your information, and you can find out how much you may be owed. And in this person's case, they were owed almost 20 months of their pay. And so the lesson here is, just because the Employment Standards Act says that your employer can do something, and certainly just because your employer says you can do something, does not mean that you don't have any rights.
Okay, so if you want to get in touch with Jon and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. Let's kick things off by taking our first call. Jon, these calls come from your radio show across Ontario and Canada, where you take questions live from listeners about their employment issues. Take a listen.
What could someone expect in Ontario for severance pay for 15 years of service, white-collar executive, 40? When they give you a separation agreement where they extend the period of termination and they state that, we'll employ you for the following 2 months, if you should leave before then, are you still entitled to that separation pay that they initially promised, or are you at risk of losing that?
What do you think, Jon?
Well, yes. If you leave before that period of working notice is over, you will, first of all, lose the rest of the compensation that you would have been paid during the working notice. And very importantly, you will lose the ability to claim any severance thereafter. So it's a resignation, and you have lost big time. So again, this is one of those mistakes that I talk about that you cannot take back. So let's pull up the Pocket Employment Lawyer and see what this person could actually be owed if if they negotiate their entitlements and they work until the end of this. We see this as a person who is an executive who has been working for 15 years, earning $142,000. And you see the compensation owed here is 15 months. 15 months compared to the 2 months they have been owed. This is well north of $100,000. And if they sign a severance agreement, they will throw that away. And importantly, if they leave before the end of the working notice period, they will throw that away. Your employer can provide some, or in some cases, all of your severance by way of working notice, and you cannot leave before that working notice period is over. Very important.
And you can make huge mistakes and leave a lot of money on the table.
That's right.
Okay, so let's take a short break. We're going to go through all of this. When we come back, employment lawyer Jon Pinkus from EmploymentLawyer.ca will walk us through the things you should do when you're fired. Stay with us. have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. And welcome back to Ask a Lawyer. Employment lawyer Jon Pinkus from EmploymentLawyer.ca is taking your employment law questions. If you want to get in touch with Jon and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We have lots of calls and questions coming in, Jon, but before we jump to those, let's talk about today's main topic, what you need to know when you get fired. So let's go over some 5 key points, starting with number 1. Pull all your documents related to that job. What would that be?
Right. Well, before you speak with a lawyer, you're going to want to have all the documents pertinent to be able to assess any of your entitlements, whether that's severance or bonus or other things. So the first thing, of course, we want to have is your severance offer, termination letter, however your severance or termination was communicated to you. If your employment was terminated for just cause, we're going to want to see the reasons that the employer is claiming for just cause before we get your side of the story. We're also going to want to have any bonus plans that you have, and we're going to want to have any documents talking about your job description. Now, if you don't have one of these things, don't panic. In fact, if you don't have an employment contract or an employment agreement, that's probably a good thing because those things typically don't serve you. But if you do have these things, we want to make sure that we can give a holistic assessment and an accurate assessment of what you're owed.
Okay, number 2, return your employer's property and figure out a time when you can retrieve your belongings.
Yes, please return your employer's property. Do not hold it as collateral or a bargaining chip or whatever you want to think of it. It is not yours. You have to give it back as soon as you are let go. We're talking about not just physical property, but electronic property, shared folders, electronic data, anything that does not belong to you. Similarly, you're going to get your property back, electronic or otherwise, so you can make arrangements to do that either by going to the workplace or setting up a courier.
And what if you don't give it back?
If you don't give it back, your employer can actually sue you for it, and I have seen this happen a number of times over the years. And it's a very uncomfortable place to be in, and what should often be a very straightforward severance negotiation. So don't make things harder than they need to be for yourself.
Okay, number 3, what you should do when you lose your job is do not accept any termination papers without legal advice. Do not do that.
Do not do that.
Do not do that.
That's right. And this, we can probably say, is more important than all the rest of the points put together. Not to denigrate any other points, they're all important, but this is the big one. If you sign a severance offer before you have gotten legal advice, that is a mistake that you cannot undo. We cannot undo it for you. If you've signed a release, that's it. And this is devastating because the majority of severance offers are well below what you are actually owed. So maybe it's a good severance package. Maybe you are with that 1 or 2 out of 10 people where the severance package is actually adequate. But before you sign off on it, make sure you speak to a lawyer.
Okay, number 4, apply for employment insurance.
Right. Employment insurance is something where the rules are unfortunately always changing, so you do want to check in with Service Canada, but you should know that often you can lose the ability to apply for employment insurance if you wait more than a few weeks after you've been notified of your termination. So you want to go online and make sure you're aware of those rules. Now, you often cannot get employment insurance at the same time as severance. In fact, that was the standard rule until they suspended that rule for COVID. But there may be situations, in fact, most situations, where you're going to have to wait until your severance runs out before you can get employment insurance. Nonetheless, you still want to make sure you have that application in.
Okay, last on our list of 5 things someone should do when they're fired. Go to pocketemploymentlawyer.ca.
Of course, pocketemploymentlawyer.ca is a great tool. It's a free tool. It's an anonymous tool. We have lots of various modules there that you can use. There's a module talking about if you've been fired for just cause, if you're truly an independent contractor, and of course, the most important of all, the severance pay calculator, which is the most used, and that is how you can find out. You go right there, you put your age, your position, your length of service, and you find out if your severance package is adequate and whether you should be speaking to an employment lawyer.
Okay, great advice, great information. Let's listen to another phone call from one of your live radio shows. Take a listen.
My wife recently had surgery on her back, There were some complications, and she has to stay off work for a while. Now, she's been on long-term disability for over a year, and now the insurance company is telling her that she has to go back to work in a few weeks or they will cut off her insurance. She can't go back to work. That's what her doctors are saying. And now her employer is also saying that if she doesn't go back sometime soon, they will fire her and replace her. We really have no idea what to do.
Wow. Okay, John, what do you think?
Wow. Well,
Wow.
we've got two antagonists here, right? We've got the insurance company and we've got the employer, and both have to be dealt with decisively and with the help of legal professionals. On the insurance front, if you are unable to work and you have a policy in place and your doctor substantiates that you're not able to work, you should be receiving your disability benefits and you should be speaking with a disability lawyer right away. In fact, on Pocket Employment Lawyer, we have a tool for disability to go through to see if you have something that you can discuss with a lawyer there. The other thing, as far as, in the workplace is concerned, your employer cannot take away your job if you are not able to work for a medical reason. They cannot fire you for a medical reason. If they do that, not only are they going to owe you severance, but they could actually be liable for human rights damages against you. And so this is a person who's going to be owed their full severance if they're let go, and they could have additional compensation they're owed in addition to that.
Okay, let's take a short break, and when we come back, we'll hear from someone questioning their relationship with their employer and discuss forced demotions. Don't go anywhere. We'll be right back. Questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Jon Pinkus from EmploymentLawyer.ca is taking questions about your workplace rights. If you want to get in touch with Jon and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We still have lots of questions and more to discuss. Here's another call from your radio show. Take a listen.
I've been teaching a class about 9 years, and they say that I'm an independent contractor, but what I was reading online is that if I work in a place that I use all their equipment, I'm considered their employee. So I'm not sure.
John?
Well, this is another example of just because your employer says something does not make it so. In this case, it does not matter if they're calling you an independent contractor. In fact, in many cases, it doesn't matter if you've signed an agreement agreeing to be an independent contractor. What matters is, are you actually an independent contractor or are you an employee? There's a number of things that we look at. We look at your financial dependency. We look at whether you are providing the tools or they're providing the tools. We look at whether you have an opportunity for profit. But at the end of the day, what we're really looking at is, who are you in business for? Are you in business for yourself or are you in business for them? And if you're in business for yourself, then you should have pretty much free reign to do whatever you want, just like someone that you would hire to do something. You can't tell them the rules, right? But if you're in business for someone else, for someone else in terms of going into the office every day, 9 to 5, you're working for them, you're taking direction from them, chances are you are an employee. And if you're an employee, that has huge implications. It has implications not only for severance, but for overtime pay, for vacation pay. We have a great independent contractor tool on PocketEmploymentLawyer.ca, so you want to log on to that, check that, it's totally anonymous, and then you may want to check out the severance pay calculator if you've been let go.
Okay, and your firm has helped non-unionized workers through all kinds of problems. Let's take a look at an example based on some of those matters. After working 22 years in a senior professional role, my boss wants to move me to a junior position. In an email, he said that because I'm 64, I should be working in a less stressful role. If I refuse, he'll fire me with 2 weeks' pay. Should I accept this?
Wow, amazing that we still have these things happening, isn't it?
We're both looking at each other like, wow, really? Is that real?
That's
a real
right.
question. It is.
It's real, and you know what? It's actually not that surprising, unfortunately. I see it all the time. 17 years after mandatory retirement was abolished in Ontario and ageism was made illegal, but nevertheless, we see these things. Well, no, of course, if you're not inclined to take that junior role, you should not be taking that role. And if you are let go, you're going to be owed a heck of a lot more than 2 weeks' pay. In fact, I could tell you, but why don't we look at the Pocket Employment Lawyer, the severance pay calculator, and see what this person is owed in the circumstances. Well, we see someone who's 64 years old, working as a professional, 22 years, earning $90,000 a year. This is a $180,000 entitlement, plus, by the way, anything they are owed for benefits over that time. And you got to think, this person is probably not going to have an easy time finding a job if they've been in the same place for 22 years. They haven't had to look for a job in a long time. And they may face ageism elsewhere. So it's all the more important to get the employment advice that you need before you sign off on something.
And all of that money he'd be leaving on the table as well.
That's right. And once 2 years have passed, that's it. No matter how unjust it is, you can't go after it. So you need to act, and time is not on your side.
Okay, let's take one last break, and then we're back with Jon Pinkus, partner at EmploymentLawyer.ca, answering your questions about rights for non-unionized employees. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Jon Pinkus from EmploymentLawyer.ca is answering your employment law questions. You can connect with his team by calling 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. Let's answer another question that came in and your team encountered this week. I worked for a business that was just sold by the parent company. It doesn't look like the new owner wants to keep me on. I've asked my new and old employers about a severance package, but neither are getting back to me. What should I do?
This is another one of those really uncomfortable and actually quite unfair often situations for employees that they're placed in when there's a change and no one explains to them what the implications of are that change. Well, here's the reality. When your company is sold, and we're talking about an asset sale, not a share sale, but the assets are sold and there's a new owner, your employment at that moment has actually been terminated. Your employment is over. And right at that moment, by selling the company to a new buyer, your old employer owes you severance. Now, if you don't become employed with the new company, then the question is, how much severance are you owed, right? So if the new company offers you a new job, and that job is quite comparable to the job that you had with the company you used to work for, then you may be owed very little severance. But if you're not offered a job, or you're offered a job that is just completely non-comparable with the job that you had before, then you're not only owed severance, but you're going to be owed your full severance. So in this case, if the company is not getting back to you, then what you should be doing is you should be speaking to us so that we can pursue your old employer for your full compensation. And if you go on PocketEmploymentLawyer.ca and you plug in your information severance pay calculator, you will see what your entitlements are, and it's the same like everyone else.
Okay, let's jump to our final question of the show. Can an employer put an employee on unpaid leave or fire them for cause if they don't get fully vaccinated against COVID-19? This question is still around.
This question is still around, and I have to say, this is a question that I have probably been asked more often than any other question in my career.
Really?
And I think a lot of other employment lawyers would say the same thing. This is a huge, huge issue. A lot of companies placing people on leave or firing them for just cause because they have not been vaccinated. And in many cases, it doesn't matter if they're working from home, working from the workplace, they apply the policy to everyone. Here's the reality on that. If your employer is required by law to have its employees vaccinated, so perhaps a long-term care home in Ontario may be one of those examples. We have in other provinces certain industries that are required by law. then that employer may be able to place you on an unpaid leave. But if you are not one of those companies, if you're not one of those companies where it is required by law and the company terminates your employment, then you have the option to pursue your full severance, because not becoming vaccinated is not going to be just cause in those circumstances by and large. So you want to speak to an employment lawyer right away so we can talk about your situation, figure out if you're owed compensation, find out how much compensation you are owed.
So an employer can fire an employee for not being vaccinated. They just have to pay them full severance. Is that what you're saying?
Well, in certain cases, there may be human rights issues as well. In many cases, actually, there may be human rights issues as well. But certainly, in the vast majority of those cases, those employers are going to owe severance to those employees.
It seems like this conversation is going to continue, even post-pandemic, continuing for months, maybe even years to come, around the COVID issue, because a lot of people, as you said, this question keeps coming up over and over again. So going forward, what would you advise employees and employers around the vaccine issue?
Well, the most important thing for them to remember is that no matter what, we cannot stop you from losing your job. We cannot physically prevent the company from letting you go. So there's not much that you can do in the interim. You may be able to request an accommodation request. You may be able to submit documentation in support of that. But other than that, all you can really do is wait for the other shoe to drop, so you can feel free to speak to us. But there's not much you can do until you've actually been given that termination letter.
And what about the employer? What advice do you have for them?
Well, you want to make sure that your vaccination policy complies with human rights legislation, and you want to make sure that you're prepared for what liabilities you may have if you place people on leave or terminate them for cause.
Jon, thank you so much for being here today. It's been wonderful. You can catch legal experts from EmploymentLawyer.ca on Ask a Lawyer every Wednesday on CP24. For more information on this show at EmploymentLawyer.ca, visit cp24.com/askalawyer. Join us again next week as we go in depth on employment rights for injured workers. Thanks for watching.